Assalamualaikum warahmatullahi wabarakatuh to Dr. Fahmi and my classmates. My group will be presenting about the workplace responsibilities and rights. So I am Muhammad Azrin bin Muhammad Yamin. So the first thing we have to know about the human resource, which is HR. It is a department or a section in a company that is in charge with finding, screening, recruiting, and training job applicants, and also administering employee benefits programs, including social securities, health insurance, educational help, and employee discount program. So HR professionals must help create a workplace with environment that honors fairness and also protecting the individual privacy threats to all workers with dignity and respect. The workers have rights which are not fully written down in a contract or any agreement. So the employee and employers should have a seminar or induction so that they both have a knowledge about their rights or any possible things that can lead to termination. So what is the right involved in workplace? So actually, in Oxford Dictionary, rights is defined as a moral or legal claim to have or to behave. For example, does an employee have the right to privacy of communication in personal matters when using company's computer or during working time? No, right? So also, does employee have rights to use personal computer for working purposes? Or company has a right this personal computer things, the company has a right to command such thing because there are many reasons for this, such as to ensure the employee securities and the safety. Since their employers are having the employee to be working with them, so they need to make sure things are working properly. So second thing is about equal employment opportunity, or we can call it EEO. So EEO is a freedom from discrimination on the basis of protected classes such as race, color of skin, sex, national origin, religion, age, disability, or genetic information. It is a federal and state fair employment laws which guarantee EEO rights, which are enforced by Equal Employment Opportunity Commission (EEOC) and its state counterparts. Affirmative Action Plans (AAPS) is an employer's standard proactively recruiting, hiring, and promoting women and minorities or disabled person or any veterans to make sure making sure to amend their historical wrongs. This is also a moral social obligation to eliminate present and past discrimination. So according to Employment Act 1995, which was latest amendment was on 1st April of 2012, the Act of state the right of both employer and employee, the obligation or responsibilities they are obligated to fulfill and to have the legal protection. However, This act is only covers the workers who are wages under RM2000 monthly, and all workers and all manual workers, such as they are using their working without using any equipment. They are using their raw physical energy, which usually involving their physical activities. So employment contract is a contract which was made when the employee passed the interview made by the employer. So they are recruited, and then the employment contract is made. So in that agreement, or we can say contract, it is the above between both parties, which sets out the right, responsibilities, and duties. It is a written contract and usually stated in the offer letter from the employer as it is required by the law. If the employees begin working, it is appear that the employee accepted the job of the employer's term, even if they are unaware of them. So it is important for the employee to read thoroughly the employment contract. So the employment agreement should address all particulars and the relationship, including base pay, incentive compensation basis, and supplementary benefits or the previously requisite. So it is important to know the key functions in performance criteria, terms and conditions for termination employment. Employment at will states that employers have the right to hire or to fire whoever they chose, and employees can quit at any time with or without notice. But this is usually different and varies among the companies. So important to include non-compete agreements which prohibit individuals to leave an organization from working if they employed in the same line of business for a specific period of time. So non-compete agreement is a clause to prevent ex-employees, or we can say the former employees, from competing against their former employers by restraining them from engaging in a particular trade or business which may be demarcated by a geographical area and or limited for a period of time. So a legal agreement in a contract, non-compete agreement is also a legal agreement in a contract which disallowing the employee from revealing proprietary information, or we can say a secret, to the company to any other parties after the employment period is over. So it is important for the market, it is important to the company to make this agreement to keep in their place, to make sure they have a place in the market, of course. So parties that should be involved in this non-compete agreement is the employees, contractors, and the consultant. Next is the non-piracy. It is also a contract may also included in a non-piracy agreement which bar the former employers from soliciting the business from former customers, clients for a period of time. So the business will be affected if the agents who have ties with those customers quits. It is different between owning a business and renting one. It is not something wise insurance agency owners want to handle alone. So they are suggested to be working to make the agreement with any other parties to make sure the bond is being kept handfully. So non-solicitation of current employees can be incorporated into an employment agreement where these limitations are created to protect the company from former employees attempting to recruit former core workers, clients, essentially poaching talent of business. So according to a 1996 law, theft or trade secrets of federal crime punishable by a fine of up to $5 million and 15 years in jail. So the employer rights in this area include the following: the right to keep trade secrets confidential, the right to have employees bring business opportunities to the employee first before pursuing them elsewhere, common law copyright for workers, and other documents prepared by employees or employers. So soliciting is the contacting customers to persuade the customers to do the business with a new different of competing firm. So non-soliciting agreement is for many firms. They serve a useful role in many organizations. They devote time, money, resource, whatever they have, to make sure the growth in their client base and customer list, as well as significant assets to keep the customer list discreet. This is important to make sure to protect their assets or the customer list. So the next one is intellectual property. An area often covered in employment contract is protection of intellectual property and trade secrets. Employers have rights in this area, including these three: keep trade secrets confidential, first refusal, a common law copyright. So a wrongful discharge is also refers to termination of an individual's employment for reasons that are illegal or improper. For example, the illegal reasons for termination is sexual harassment, violation of all written employment agreements, and many more. So it is said that if a person is fired from a job and they believe it is the employee they believe it is a wrongful decision, especially if it was done without cause. However, the legal definition of wrongful termination is very specified. It's also against the law to dismiss an employee for filing a legal complaint against the company or for reporting the firm's misconduct as a whistleblower. So whistleblower, my friend Arif will be presenting or will be discussing more later about the whistleblower. So the next is constructive discharge. Constructive discharge is the process of deliberately making conditions intolerable to make an employee quit. So an employee is constructively discharged when they resign because they can no longer stay on the job due to a hostile work environment. Hostile work environment, according to a research, one out of 5 workers has experienced workplace abuse or sexual harassment or bullying, verbal abuse, or unwelcome sexual attention. So public policy exception is any employees is fired for a reason that violates policy and the employee have the right to sue the employee So an employee gets fired for exercising their legal rights, such as right to vote. Employees who refuse to do an unlawful conduct, such as fabricating reports or submitting a false corporate tax paperwork, may be fired. The implied contract exception is the employee cannot be fired as long as they perform their job, and a non-service promises of continued employment and lack of criticism of job performance imply continuing employment. So due process. Due process is a fair treatment to the normal judicial system, which is especially a citizen entitlement of a judge and hearing before impartial judge. A series of legal process conducted in accordance with established norms and principles in a system of jurisprudence for enforcement protection of private lives. The organizational justice is a fairness of decision made by employer, advocate, and organization. So elements of justice. There are 3 elements in justice, which is procedural, distributive, and interpersonal. So procedural focus on whether the procedure that lead to an action were appropriate and clearly understand, and whether they provide an opportunity for employee, and it is a perceived fairness of a process used to make decisions about the employee. So distributive is the perceived fairness in the distribution of outcomes per disciplinary action based on favoritism when some are punished and others are not. This is clearly a wrongful decision. So interpersonal, which is the extent to which a person affected by an employment decision feels treated with dignity and respect. Is an adequate explanation provided to explain the decision, or is it the employee treated consistently? So fairness is the employee who feel that they are not treated fairly, may respond in a number of ways, sometimes even counterproductive. So procedures of making companies may improve perceptions of justice by providing procedures to deal with employees' complaints. In union-free firms, the complaint procedures differ from those for unionized employees who typically have a formal grievance procedure specified in their union contract. So due process back then is the due process, and union-free firms are more varied and may address of a broader range of issues. So another terms in policy is open door policy. So many employers use an open door policy, which allowing workers who have a complaint to talk directly to someone in management. However, if this may be mishandled, so union-free firms have it more beneficial to have more formal complete as it is written and more systematic due process than the open door policy. So different company may have different way to solve their complaints from the workers. So trust is the for employees to trust these methods. Companies should have communicate decision clearly and give employees an opportunity to provide input, for example, using arbitration process. Arbitration is a process that uses a neutral third party to make a binding decision, thereby eliminating the need to involve the court. So the next presenter is Arif. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Arif Hanafi bin Mat Zaki. I will continue the presentation on workplace rights and responsibilities. The first one is the compulsory arbitration. Common feature in union contracts, some firms use compulsory arbitration, which requires employees to sign a pre-employment agreement stating that all disputes will be submitted to arbitration. These agreements require employees to waive their rights to pursue legal action until the completion of arbitration process. A legal check of compulsory arbitration as part of the Alternative Dispute Resolution ADR should be done before adopting this practice. Some organizations allow their employees to appeal disciplinary action to an internal committee of employees. This panel reviews the action and makes recommendations or decisions. Peer review panels use fellow employees and perhaps a few managers to resolve employment disputes. Some organizations ensure process fairness through ombudsmen. Ombudsmen is the individuals outside the normal chain of command who act as an independent problem solver for both managers and employees at many large and medium-sized firms. Ombudsmen have effectively addressed complaints about unfair treatment, employee-supervisor conflicts, and other workplace behavior issues. Ombudsmen address employee complaints and operate a high degree of confidentiality. They can also improve employee perception of procedural justice. Ombudsmen, as well as other individuals in groups who oversee disputes, will sometimes use mediation as a tool for developing appropriate and fair outcomes for all parties involved. Mediators may use either a facilitative or evaluative approach to dispute resolution. Facilitative techniques foster communications amongst the parties to help uncover options for settling. The variety of ADR methods available to employers to resolve disputes in employment relationship are broad. The right to privacy is defined in legal terms as an individual's freedom from unauthorized and unreasonable intrusion into personal affairs. So, for the Privacy Act of 1974, this act was an act to protect individual privacy rights in the United States. It includes provision affecting HR record-keeping system. This law applies only to federal agencies and organizations supplying service to federal government. However, similar laws in some states with somewhat broader scopes have also been passed for most part states rather than federal law regulates private employers on this issue. Record keeping and retention practice have been affected by a provisions of the Americans with Disabilities Act known as ADA, requiring that all medical-related information be maintained separately from all other confidential files. The Health Insurance Portability and Accountability Act HIPAA also includes regulation designed to protect the privacy of employee medical records. Both paper and electronic files must be safeguarded. As a result of all the legal restrictions, many employers have established several separate files for each employee. So for the access, it is important to establish access restriction and security procedures for employee records to protect the privacy of employees and to protect the employers from potential liability for improper disclosure of personal information. Individuals and social security number, personal address, and other contact information should be protected. Next, the Data Protection Act requires employers to keep personal records up to date and keep only the details that are needed. The following guidelines are offered regarding employer access and storage of employee records. First, restrict access to records to a limited number of individuals. Next, use confidential password for accessing employee records about various HR database. And then, set up separate files and restrict databases for particularly sensitive employee information. First, employee records of outdated data, and last one is to release employee information only with employee consent. So for the personal files and records are usually maintained for 3 years. However, different types of record should be maintained for shorter or longer period of time based on various legal and regulatory standards. So then is the technology. Another concern is how electronic records are maintained and secured, especially given advances in software, email, and mobile technology. Organizations should establish an electronic record policy to ensure legal compliance and avoid violating individual personal rights. So for data privacy is becoming increasingly important with the growth of mobile technology and the use of applications or apps that offer various functionality. Many applications collect information about users. So it is vital to ensure that an organization policies accurately and completely identify all data being collected so that users are aware of how their personal information being handled. So then, the next one is the freedom of speech. 3 situations in which employee freedom of speech might be restricted, including expressing controversial views, whistleblowing, and using the internet or other communication-based technology. Question of free speech can arise over the right of employees to advocate controversial viewpoints at work. Can an employee be disciplined in a situation like this? The answer is likely yes, if this disciplinary action can be justified by job-related reasons and the company follows due process procedures. However, simply because an employer might not be able to punish who make inappropriate statements that embrace the organization, should the employer do so? Perhaps an employer should not, because employees might view this as heavy-handed and overreaction. So for the best way to handle these concerns is to attempt informal resolution first, clearly outline the boundaries and standards for appropriate behavior in a formalized policy that address workplace expectation and have signed non-disclosure privacy agreement. So the next one is whistleblower. Whistleblower is the individual who report real or perceived wrongs committed by their co-worker or employers are called whistleblower. Several laws such as Sarbanes-Oxley Act and the Dodd-Frank Act protect corporate whistleblowers. For instance, the Sarbanes-Oxley Act is intended to remedy companies' ethical breaches by requiring organizations to properly report financial results, encouraging ethical business practice, and the last one is providing protection to whistleblowers. Then for the Dodd-Frank Act, also protects whistleblower and provide financial incentive to individuals who report wrongdoing. In addition to paying fines, a company that has found guilty of retaliation is required to reinstate the individual back to his or her job, provide back pay or double back pay to make up for lost compensation, and cover any costs associated with legal counsel. Employers need to address two key questions regarding whistleblowing. The first one is, when do employees have the right to speak out with protection from retribution? And when do employees violate the confidentiality of their job by speaking out? Even though the answer may be difficult to determine, retaliation against whistleblower is clearly not appropriate or legal. The culture of the organization often affects the degree to which employees report inappropriate or illegal actions internally or resort to using outside contacts. Consequently, HR professionals should be actively involved in helping the organization develop an ethical culture by creating fair and ethical policies. Employees of private sector employers can be monitored, observed, and searched at work by representatives of the employer. Then is the court decision. Several court decisions have reaffirmed the principle that both private and public sectors employers may search desks, files, lockers, and computers files without search warrants if they believe that work rules have been violated. Numerous employers have installed video surveillance systems in their workplace. Some employers use the system to ensure employee security, such as in parking lot, garage, and dimly lit exterior areas. Other employers have installed them on retail sales floors, in production areas and parts, and in inventory rooms to reduce theft and shrinkage. By installing the video surveillance system, it is important that employers using that method to develop a video surveillance policy, inform employees about the policy, conduct the surveillance only for legitimate business purpose, and lastly, strictly limits those who view the surveillance results. Employee morale should be considered when developing policies because employees may see monitoring system as a sign that they are not to be trusted, which can lower their commitment and positive impression of the organization. Then, for the performance, employee activity may be monitored to measure performance, ensure performance quality, and customer service check for theft, and enforce the company policies and rules. The common concerns in a monitored workplace usually centered not on whether monitoring should be used, but on how it should be conducted, how the information should be used, and how feedback should be communicated to employees. Organizations should strive to collect information that is needed to manage business operations, but not to track every detail just because they can. A workplace investigation is not an effort to prove or disprove allegation or to determine whether allegations are true. A workplace investigation is designed to find facts and determine what happened or what is happening in a situation. An investigator for the organization has the responsibility to look beyond the simple incident or accusation to examine the situation. The US Constitution protects public sector employees in the area of due process and seizure and privacy at work, but private sector employees are not protected. Whether it occurs on or off the job, employs unethical or illegal behavior can be a serious problem for the organization. Then, for the workplace investigation, this workplace investigation can be conducted by internal or external personnel. The following best practice should be used when conducting workplace investigation. The first one is to develop a good working plan that outlines how the organization should respond to crises before they occur. Confidentiality should be a high priority throughout the investigation, and all important incidents should be properly documented. Specify whether human resource or another party, like an attorney or an accountant, will conduct the actual investigation of workplace incident. If possible, select an objective and impartial investigator who does not have any professional connections to the individual being investigated. So, investigate problems quickly before evidence can be tampered with or destroyed, and begin interviewing key witnesses. Investigate wrongdoing within several days after being made aware of the incident, and try to finish the investigation within 2 weeks. Then, for the credibility, use the stories and information collected to conclude the investigation and recommend any remedial steps that should be taken. Present the results of the investigation to key decision makers and make appropriate recommendations. Investigation serve a visible evidence that the organization takes employee concerns, policy, and procedure seriously. Moreover, investigations show that an organization will diligently research all evidence related to a claim to determine what has happened. This will build a confidence of fairness among those who are aware of the investigation and beyond. An investigator who remains impartial keeps an open mind and respects the impact of their work has a profound impact on the fairness in the organization. Policies act as general guidelines that help focus organizational actions. Policies are general in nature, whereas procedures and rules are specific to various situations. The important role of all three requires that they be reviewed regularly. So for procedure we provide customary methods of handling activities and are more specific than policies just now. So for rules are specific guidelines that regulate and restrict individuals' behavior. They are like procedures in that they guide action and typically allow no discretion in their application. Rules affect a management decision that action can be taken or not taken in each situation, and they will provide more specific behavioral guidelines than policies do. So that's all from me. Thank you.
Hi everyone, it's me Alia, and I will be emphasizing more on the work responsibilities and the after effects when one's neglected his or her workplace responsibility. I believe both my good friends Azrin and Arif had done an exponential job well done in explaining the rights, responsibilities, and other concepts that are interrelated to them. Nevertheless, please bear a few more minutes with me as I walk through with you guys on this particular topic for our part 3. First and foremost, let us get back into the definition of work responsibilities. Work responsibilities is when an employee completes all of their job duties stated within the job description and adheres to the company policy and procedures professionally and to the best of their ability. The simplest analogy I could suggest would be assignments. By doing the assignment with the best effort we can according to the question requirements, we are actually fulfilling part of our responsibility as a student. The same concept applies when we take a step into a real-life working environment. So, why does work responsibility is extremely important? Well, responsibility is important in the workplace because it shows your professionalism, can advance your career, helps build professional bonds with co-workers, and shows company leadership that you are a valuable employee. Supervisors value employees who exhibit responsibility because they know they can trust you to complete tasks on time and submit the high-caliber work. Responsible employees are professionals with a consistent work ethic who take actions daily towards their professional goals. Now, it came to the big question of how. How shall we achieve more work responsibility at our workplace? To answer that, firstly, when working, to show you are a responsible employee, take the first step by ensuring you are fully aware of your job responsibilities. Next is integrity. Integrity is a skill and trait that takes time to develop. Employees with integrity follow a strong moral code and can be trusted to make decisions that are ethical and benefit the company and those around them. Thirdly, resilience. In other words, the will to continue when faced with obstacles and the stamina to continue after you have failed, which could lead to a successful employees and a dynamic and growing company culture. Nevertheless, do accept the consequences of your actions to take accountability. And when you have to make a decision at work, do so with confidence. Being decisive means making informed decisions and having the certainty to see them through. These are the 5 ways in which work responsibility can be achieved more. Have you ever seen a handbook or a manual book? I bet most of us had. Well, in every company or workplace, there must be an employee handbook. This handbook provides guidance and information related to the organization's history, mission, values, policies, procedures, and benefits in a written format. It is also viewed as a means of protecting the employer against discrimination or unfair treatment claims. It is an easily accessible guide to the company's policies and practices, as well as an overview of the expectations of management. Basically, the characteristic of a common handbook will be it must be written in a common language so that it is readable and also usable. Then, all controversial phrases are usually eliminated in order to avoid misinterpretation by either the employee, employers, or general law officers. In addition to that, disclaimers are written clearly instead of using small fonts at the bottom corner of the page. This is to ensure that employees are completely aware of that section. The handbook is also updated from time to time whenever necessary. Let's say there is a new issue to be found or any changes are amended on the existing process. Last but not least, with the technological era we are in now, most handbooks are now in the form of an e-book so that they can be accessed anywhere and everywhere for easy references purposes. Moving on, I will now be explaining about upward communication. Upward communication is the process by which lower-level company employees can directly communicate with upper management. This enables management or managers to learn about employees' ideas, concerns, and information needs. This type of communication are usually in the form of employee satisfaction surveys, suggestion programs, performance reports, and also company meetings. Hence, it is our responsibility as an employee to be attending, filling in, and fulfilling all the surveys, programs, and meetings held, as it is beneficial for us too at the end of the day. Oh, let's sit back and take a look at a short animation video prepared explaining more regarding upward communication that you should know. Now that we have watched the clip just now, I really hope everyone could really take note that it is important for us to take part in this kind of effective communication in the workplace, as it affects us personally and the organization as a whole. Taking into consideration that not all communication, either upward or downward, is working effectively in a certain workplace, we must prepare ourselves with the existence of problematic employees or management system. Problems. Whenever we go or wherever we go, there must be problems recurring. It's the same when we are in a workplace. The common workplace problems are basically disciplinary issues caused by problem employees, such as breach of company's confidentiality, in other words, misconduct behavior, quality deficiencies, safety violations, and also insubordinations. Therefore, the highlighted question here is, what is management rules when these problems occur? The first thing is to identify violations and other behavior problems that the said employee had done. Next is then taking steps to correct them. However, if it became much worse, the Human Resource Department HR will be assisting in terms of disciplinary action. Hence, it is vital for managers and supervisors to be trained at the right time when discipline shall be used to avoid mistakes in disciplining. I had also laid down a video on how we can spot a toxic colleague or problematic office mate. Please enjoy.
How to spot toxic employees in the workplace. Can one bad apple really spoil the whole bunch? As it turns out, in the workplace, it can. Toxic employees can be the reason relatively good employees leave the company, slack on their work, and endure more stress and burnout. Interestingly enough, a study conducted by Cornerstone concluded: 1. Good employees are 54% more likely to quit when they work with a toxic employee. If the proportion to toxic employees on their team grows by as little as 1 in a team of 20. 2. As toxic employees make their coworkers significantly more likely to leave, replacement costs rise greatly. Hiring a single toxic employee into a team of 20 workers costs approximately $12,800, whereas hiring a non-toxic employee costs an employer an average of $4,000. Toxic employees can create a huge mess within the workplace, not to mention take a toll on the company's overall well-being in more ways than one. This is why it is important to understand how to spot a toxic employee and mitigate the effects of their toxicity before it gets worse. To spot a toxic employee, you must be able to gauge the following. 1. The likelihood of a team member being dismissed for toxic behavior. 2. The likelihood of a team member leaving voluntarily. And 3. The workplace performance of team members. Based on these three figures, 3 to 5% of all of your employees will meet the criteria for being termed as toxic. Now begins the difficult but necessary task of filtering out the bad apples so the good ones can thrive. To begin, you must factor in employee performance to segregate the toxic employees from the non-toxic employees. To do this, calculate these measures of employee performance. Number 1. Customer Satisfaction, or CSAT. This score indicates how satisfied customers are with the service they receive. Number 2. Average Transaction Time, or ATT. This is the average time an employee spends on a given customer transaction. These two performance indicators are used to understand how the relationship between the quality and quantity of an employee's work was impacted by the presence of toxic coworkers. Employees who are self-proclaimed rule followers, as well as those who struggle to show up to work on time, have a low level of reliability, and are not inclined to help others, are often markers of a toxic employee. Employees can set benchmarks according to specific company-wide standards and expectations. Employees that consistently fail to meet such criteria can be considered toxic employees who impact the workplace. To that end, it is critical to focus attention on avoiding toxic employees and eradicate such behavior before it spreads.
Based on the video just now, employees with problems will be taken into disciplinary action. Talking about disciplinary actions, there are two disciplinary actions in the workplace, which are positive discipline and the other one is progressive discipline. A positive discipline is based on the philosophy that violations are actions that usually can be corrected constructively without any penalty. On another note, a progressive discipline incorporates steps that become progressively more severe and designed to change the employee's inappropriate behavior. The sequence for this particular action usually starts off with a verbal and written reprimands in the form of suspension before resorting to a dismissal. However, there are a minority of managers or supervisors who are reluctant in executing disciplinary action against the problematic employees. One of the reasons why they do not take this seriously of this matter is because of the fear of lawsuits, in addition to the lack of support by the higher management. Moreover, there is a certain organization that has this cultural thing set in which disciplinary actions are always avoided, just like bribery, that seems to be a normal kind of gift in their organizational culture. The fear of losing a friendship and avoidance of time loss also contributes to the fact that this management is reluctant to apply disciplinary action to their employees. Well, to sum up, the most of them have a conflict of interest whenever this issue of a problematic employee happen to be in their company. But let's say the 50% or more possibility that these problem employees are taken for disciplinary action, it is part and parcel of the workplace responsibility that the managers or supervisors to document everything that happened. This process of documentation consists of documents that provide proof or evidence for something or a record that your organization keeps and uses to inform decisions within your company. In terms of the employee's problem, the documentation shall consist of performance and behavior expectation, the employee's specific failure to comply, prior warnings or counseling with the employee, expectation for future conduct, and also consequences for failure to correct deficiencies. These documents shall determine the whole process output for the progressive discipline taken upon to the said employee. I have been explaining the sequences for the progressive discipline, and now we came to the last part of it. As you can see, the process for termination can be simplified into 3 ways. The first is warnings that are given to the problematic employees either verbally or through warning letters. Next, if the bad behavior is kept on, the document report is given to a legal officers for review, and if it is approved, the employee will be dismissed from the organization. Once he or she is dismissed, he or she needs to sign a formal contract with the organization they are working with before. This contract is actually a separation agreement that clearly mentions that the employee will not sue the organization with exchange to the benefits given. Most of the time, the agreement is signed peacefully between both parties as long as both respected each other. An additional fun fact, in Malaysia does not have an at-will employment system. In summary, employers cannot just hire and fire at will. They can, however, terminate an employee's services if it is justified, done in good faith, and is procedurally fair. So let's say if you are an employee in a company, you are not problematic at all, but you got fired instead. Well, this is called as a wrongful termination. Unfair dismissal or a wrongful termination of an employee is an act where an employer terminates, dismisses, or removes an employee without providing any valid grounds of removal. It is imperative that the employer furnish strong and valid reasons for termination, and in case it is not provided, it is actually a wrongful termination. Wrongful also because the employee is not provided an opportunity to be heard. With this, even the fundamental legal principle which says listen to the other side stands violated. Wrongful termination examples include sexual harassment and/or a hostile work environment, race discrimination, retaliation over workers' compensation claims, violation of the Family and Medical Leave Act, wage and hour violation, and also whistleblower retaliation. Well, I would like to highlight here on the whistleblower retaliation. In this case, there are other reasons such as being fired for blowing the whistle on your employer as you report issues that are engaged to them such as lack of safety in the workplace or report some illegal activity in which your employer is involved. For example, if you reported sexual harassment in your workplace to the company's human resource department and you were soon fired after, that is a sign that your employer fired you as an retaliation for reporting the harassment. When this happens, as an employee, please acknowledge your labor rights and fight back either peacefully or by sending a lawsuit. An equal and fair environment workplace is vital as it is also part of our rights. All in all, that concludes the whole topic of workplace rights and responsibilities. It can be summarized that it is extremely important for us to be aware of our rights and responsibilities so that we can hold onto our ground when things seem to be shady or affect our principle of integrity. By completely understanding our rights and responsibilities, it ensures us to acknowledge that the best ethical and morality came when we knew what is right and what is wrong. In another similar perspective, it is essential that every employee understands his or her rights and responsibilities in the workplace. There are many laws that protect the safety, well-being and rights of employees at work, and it is important that employees understand their rights and responsibilities relating to them. However, you do not need to know each law in detail. But let me remind back two terms that are extremely vital in this topic, which are rights and responsibility. First, rights. Rights are what are due to you according to the law, whereas responsibilities in law are actions that you must do. So, in your workplace, there will be procedures and policies based on these laws, and it is your responsibility to follow those procedures. I will now close the presentation with a quote by John D. Rockefeller. He said that every right implies a responsibility, every opportunity is an obligation, and every possession is a duty. With that, we thank you for lending your ears for this topic. Thank you.